Hello दोस्तों let's discuss a case on section 133 CrPC. It deals with conditional order for removal of nuisance and the power is conferred on district magistrate or STM. तो दोस्तों the case relating to this provision is State of MP versus Kedia Leather and Liquor Limited. It's a 2003 Supreme Court judgment. तो दोस्तों इसमें हुआ ये था SDM had ordered the Leather and Liquor Limited, this company, to close down industries क्योंकि उनके effluent से water pollution हो रहा था. तो they contended that by the enactment of Air Act in 1974 and Water Act in 1974 and Air Act in 1981, CrPC section 133 is impliedly repealed to the extent of nuisance caused by air pollution and water pollution. Their contention is section 133 broadly deals with nuisance, and for the nuisance caused by air pollution and water pollution, there already is provision under section Air Act and Water Act. So there is no need. This is the general principle that legislature doesn't want two parallel legislations occupying the same field. And then the opposite, the state contended that these are two separate spheres, and we understand that the Air Act and Water Act is an enlargement of nuisance in the respective sphere, but they are two separate and they can coexist. So before we read the judgment of the court, let us just cull out the relevant portion of section 133. So it says that wherever a DM or SDM or any other executive magistrate, on receiving the report of a police officer or other information, on taking such evidence, the first part is that an unlawful obstruction or nuisance should be removed from any public place or from any way, river or channel which may lawfully be used by the public. So for this case, to remove nuisance from any river or channel, then what he can do, such magistrate may make a conditional order requiring the person causing such obstruction or nuisance or carrying on such trade blah 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 to remove such obstruction or nuisance or to desist from carrying on. So accordingly, the SDM, if section 133 was valid, was constitutional on the day of this order, then SDM had made a valid order. But the respondents are challenging that this section 133 is ultra vires because it has been impliedly repealed by Air Act and Water Act. So the court says, first of all, the court says that although we have already read section 133, the court refers to a judgment called Vasant Monga Nikumba versus Babu Rao Bhikanna Naidu. So in that, it is also a judgment by Supreme Court. The Supreme Court had held that it's very difficult to define precisely what is public nuisance. What is nuisance, but on the other hand, so some feature that we can gather are there should be an imminent danger. It's not about some impending danger, but there has to be an imminent danger, a sense of urgency which has to be removed, and the SDM accordingly makes an order. The court also differentiates between section 133 and section 144, both of which deal with nuisance. The court says that section 144 is more general while 133 is more specific, and moreover 133 deals with more nuisance of more urgency, more imminent danger. Moreover, unlike section 144 where it's a criminal proceeding, section 133 is a civil proceeding, and there is no concept of being accused. And moreover, as the title itself says, section 133 is a conditional order, whereas section 144 is an absolute order. So having differentiated and identified the contours of nuisance, the court says that section 133 can be culled in to remove public nuisance caused by effluent and discharge of air and water pollution. So in general, this is the intention. But now the question is, after Air Act and Water Act enactment, what is the scenario? So the court says that there is a presumption against repeal by implication. Why? Because it is believed that legislature is aware of all the laws that have been enacted, and if it has decided not to repeal something, then there is a presumption against implied repeal. And moreover, if the later act itself repeals some other acts and it has not chosen to repeal, let's say section 133, then by that legal maxim expressio unius est exclusio ulterius, that express inclusion of something automatically excludes those things which are not explicitly included. So if this, so like Air Act and Water Act have repealed some previous legislation, but they chose not to repeal Section 133. So it is implicit that the legislature did not want to do it. And then the court say that the doctrine of implied repeal, for that we need to test two or three things. The first is whether there is a direct conflict between the two legislations. Second is whether they occupy the same field and whether can they stand together. So the court in this case finds that the aim of Section 133 CrPC vis-a-vis Air Act and Water Act are separate. Moreover, Section 133 is only preventive, while these acts, Air Acts, Water Acts, are preventive, remedial, curative, penal. Moreover, they are mutually exclusive. It's not that one interferes with the other. So, like in Air Act, Water Act, there can be regulation, there can be punishment. While in Section 133, in case of imminent danger, order can be issued by conditional order can be issued by STM to show cause notice. So the court concludes that they can stand together, and hence Section 133 is not impliedly repealed by Air Act and Water Act. तो दोस्तों, आई होप आपको ये केस समझ में आया होगा. कोई दिक्कत, कोई परेशानी कमेंट सेक्शन में ज़रूर बताइएगा. मिलते हैं एक नए वीडियो में एक नए केस के साथ. टिल देन, बाय बाय एंड गुड नाइट.